of the court, superior courts is integral in upholding the Constitution of the Republic of South Africa and the rule of law. This is achieved through the work of our nation's permanently appointed by the court to the judiciary and superior courts to ensure functions optimally. And as such, the Office of the Chief Justice has allocated a budget of 297,642,000 for 2024-25, which operationalizes through the three programs, namely administration, superior court services, as well as the judicial education and support. The allocation also includes charge or revenue fund for the remuneration of judges. This budget represents a 13% decrease in the department's budget relative to the previous financial year. The budget regression therefore necessitates an ongoing innovation of implementation of the department expanding program scope in order to keep the superior courts operational. The OCJ commits to ensuring the continued implementation of the 2024-2025 program through optimal utilization of its resources. And it will continue to focus, among other things, in its mandate, one, to support the Chief Justice, the judiciary, and in ensuring judicial accountability, broadening and improving access to justice, ensure efficient court systems, and providing judicial support, and reduce the inefficiencies in court administration. Honorable members, the sixth administration was seized with unlocking efficiencies in the Superior Court to improve both access and quality. A key program in this regard was the implementation of the digital transformation strategy, which seeks to integrate technology into all areas of the courts and the OCJ business. In the previous medium-term strategic framework, the Office of the Chief Justice planned for the development and the rollout of our court online system in the Superior Court. This project is part of the integrated justice system funded and monitored through that program. The court online system has since been developed, piloted, and rolled out in the North Gauteng High Court in Pretoria and the South Gauteng High Court in Johannesburg. The Office of the Chief Justice has also planned to roll out the court online system in 7 courts in the 2023-24 financial year. It had. However, this target was not met due to system instabilities. So considerable work still needs to be undertaken to ensure that the plan of 2023-2024 is still achieved. In terms of our Constitution, Section 8.2 of the Superior Court, Section 1656, is the overall responsibility of managing judicial functions and overseeing the implementations of the norms and standards is the functions of all courts. It vests with the Chief Justice. The OCJ supports the judiciary by providing human resources and performance management systems and tools to collate and collect all the performances data that are required. The OCJ is mandated further by the South African Judicial Education Institution Act of 2008 to promote independence, impartiality, dignity, accessibility, and effectiveness of the courts by providing the educational officers. And the NDP, as I had earlier indicated, recognizes the independence as improvement of the quality of judges. SIJ has continued to offer in-person and virtual judicial training. However, virtual training has been negatively impacted by the judicial education courses attended by 1,000. This program commenced in January 2023 with in-person sessions for 1 week per month until May 2023. In addition, it also conducted courses for aspiring judicial officers. So going forward, the resourcing and the capacitation of SAJE remains critical. The training programs need to enhance the delivery by promoting effectiveness and interventions. The fight against corruption in both the public and private for our government priorities. And to this end, OCJ continues to strengthen this intent to fight the scourge that undermines service delivery. One of the fundamental human rights that is guaranteed in Section 9 is the right to equal protection and the benefit of the law, including all. So we emphasize today the measures that must be taken to promote the achievement of equality in all spheres of society. The OCJ continues to prioritize the appointment of women in senior management, and at the end of 23-24 financial year, 53% of ACJ were women and 47% men, thus exceeding a target by 3%. We still need to do more. The department also continues with efforts to forge partnership with various NGOs. Honorable members, as I conclude, the judiciary is an important part of the state, arm of the state, and it is critical for the success of our constitutional democracy. The executive will do all we can through the OCJ, other avenues to support and promote the independence of the judiciary. Chairperson, allow me and honorable members, I therefore present the 2024-25 budget vote 27 of the Office of the Chief Justice for your support and approval. Before I vacate the podium, allow me to convey heartfelt congratulations to our chairperson and the members of the portfolio on their appointment and being entrusted with this important responsibility. We are looking forward to support you and also looking forward to your guidance. Allow me also to extend a word of appreciation to the Chief Justice of South Africa, Chief Justice Zondo, who retires in August 2024. We thank him, the Chief Justice, for the wise leadership of the judiciary throughout his tenure as the head of the judiciary, and we wish him well. I would also like to recognize the Deputy Chief Justice, Mayor Mandisamaya, and the judiciary at large of their continued support. The constructive oversight role of our audit and committee risk of OCJ should also be acknowledged. Last but not least, I thank the Secretary General of the OCJ, the management of the OCJ, their staff for their tireless effort in serving the people of South Africa.
Thank you, the Honorable Minister. I will now call upon ANC Honorable Ngola.
Thank you very much, House Chair. House Chair, allow us to Minister of Justice and Constitutional Development, Tembi Simelane, the Deputy Minister Andrew Snell, all members of Parliament today, the Secretary General of the Office of the Chief Justice, Mayor Sejosengwe, the Director General of Department of Justice and Constitutional Development, Advocate Dr. Mashabane, fellow South Africans, good afternoon. Standing at the old later. Its meaning equality law means the right to participate in the making is governed, which guarantees democratic rights to all sections of in the case of the violation of rights guaranteed in the Constitution, and the right to take part in the administration of justice as judges, magistrates, attorney generals, law advisors, and similar positions. In the absence of the phrase equality before the law is no far as and misleading. House Chair, the Portfolio Committee on Justice and Constitutional Development, having considered Budget Vote 27, Office of the Chief Justice, and the Annual Performance Plan of the Office of the Chief Justice for 2024-2025, reports as follows. On the 9th of July 2024, the OCJ presented its Annual Performance Plan 2024-2025 and budget for the 2024 Medium-Term Expenditure Framework on 9 July 2024. The Office of the Chief Justice responds to Chapter 14 of the National Development Plan, promoting accountability and fighting corruption, particularly contributing to the focal area strengthen judicial governance and the rule of law by accelerating reforms to implement a judicial-led court administration, ensuring an efficient court system, reducing inefficiencies in the administration of the courts, and ensuring access to justice. The Office of the Chief Justice as a response to Chapter 13 of the National Development Plan, building a capable and developmental state by ensuring good governance in the administration of the department. The OCJ's core function is that of providing administrative support to the judiciary and has adopted the following strategic outcomes: effective and efficient administration, administrative support, improved court efficiency, enhanced judicial education and support. The OCJ is allocated 2.39 billion in 2024-2025, compared with 2.58 billion in 2023-2024, growing to 2.62 billion in 2026-2027. In real terms, the allocation of the vote decreased by minus 11.2% in the 2024 financial year. A total of 1.2 billion is allocated to programs, while the remaining 1.17 billion is a direct charge for judges' salaries. Over the medium term, 52.2% is spent only on programs. The committee knows that the OCJ is allocated approximately 2.4 billion for 2024-2025, but its budget is reduced by 446.6 million over the medium-term expenditure framework, affecting its operational budget. In particular, the committee appreciates that the OCJ plans to address the reductions through the implementation of cost containment measures. For example, travel and filing only critical vacant posts. However, the committee is deeply concerned that these will be sufficient. The committee knows that the OCJ anticipates for 2024-2025 and is engaging National Treasury on this. The committee knows that the OCJ reports as increased demand and workload that must be funded. For example, the permanent appointment of judges to the Land Court and Labor Appeals Court vacancies, particularly those at senior management level, and that provide direct support to judges. The OCJ reported its difficulties in filing vacancies, specifically the lack of budget and cumbersome bureaucracy. The committee also knows the widely expressed concerns about the state of our courts, including poorly maintained buildings and inadequate safety measures. It is therefore concerning that court administration remains fragmented, with key aspects remaining with the Department of Justice and Constitutional Development. The committee urges the executive on the finalization of the judicial governance policy and its accompanying legislation as a priority, Honorable Minister. The committee finally notes that the OCJ plans to roll out Court Online at 2 centers in 2024-2025. The progress of the Court Online project is disappointing, though, especially as this modernization project is vitally important to efforts to make the courts more efficient, and more accessible. House Chair, the Portfolio Committee on Justice and Constitutional Development, having considered Vote 27, Office of the Chief Justice for 2024-2025, recommends that the House approve it, and I thank you.
Thank you very much, Honorable Ngola. I will now call the DA, Honorable Breitenberg.
Thank you, House Chair, honourable members, Minister, Deputy Minister. On the 23rd of August 2010, the President proclaimed the Office of the Chief Justice as a national department within the public service by means of Proclamation 44 of 2010. The establishment of the OCJ was envisaged as the first phase towards an independent judiciary, a judiciary-led court administration system in order to fully realise the judiciary's institutional independence in line with the Constitution. The OCJ is headed by the Minister of Justice as its executive authority, with the Secretary-General as its administrative head. As the Minister's proxy, the Secretary-General engages and consults with the Chief Justice and other heads of court. In respect of the administrative functioning of the Supreme Courts, while the Chief Justice controls the judicial functions of the superior and lower courts, the Department will continue to support the administration of the Magistrates' Courts. Significantly, the Constitution's 17th Amendment Act designated the Chief Justice as head of the judiciary with responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. In its Budget Review Recommendation Report, the Justice Portfolio Committee of the 6th Parliament made the following observations. With regards to underspending, the Office of the Chief Justice was again unable to spend all the budgetary allocation, spending only 95% of the final allocation. Although spending has improved significantly when compared with 2021-2022 and spending in the first quarter of 2023-2024, performance has declined significantly. This, to some extent, appeared not to be in the OCJ's control. However, the ability to manage expenditure is an important indicator of how efficiently resources within a department and managed, and typically the National Treasury does not look favourably on underspending. At the outset of the 6th Parliament, the committee agreed that it is important to monitor performance and spending on a quarterly basis through oversight, but has found it difficult to achieve due to time constraints. This should be a focus area for the committee in the 7th Parliament. With regards to progress of court administration model, while the OCJ cannot answer for the Minister on the progress of the court administration model or the drafting of a lower courts bill, the establishment of single judiciary, cognizance must be taken of the Minister's statement that the policy on judicial governance and court administration had reached the stage where it was ready for engagement with stakeholders. The intention was to finalise these engagements by October, and the outcome of these engagements would inform any necessary legislative amendments. The finalisation of this policy and its accompanying legislation should be a priority, it is suggested. Not only is the establishment of a single judiciary a constitutional imperative, but also the lack of an appropriate policy and legislative framework that our judicial system experiences. With regards to court modernisation, once again, the OCJ reports that it was unable to roll out the court online system as planned. The plan was to roll out the system to 5 superior courts during 2022-2023, but the system was only rolled out to 2 superior courts, namely Pretoria and Johannesburg High Courts. With regards to technology is being employed in relation to judges' administrative matters. That is the development of the e-judiciary system, which implements the Judges' Remunerations and Conditions of Employment Act. In addition, the ICT Infrastructure Refresh project was implemented at the OCJ's data centre for the production site and the disaster recovery site. With regards to the case lines procurement improprieties, the Auditor General's findings and recommendations were noted in the previous committee concerning alleged improprieties in procurement concerning the case lines project, as well as its recommendations. The OCJ was engaged on several occasions and agree with the importance of ensuring business continuity. The OCJ has put in place measures to address the internal weaknesses that permitted the alleged improprieties to occur, and the matter is now also being litigated. The incoming committee may wish to keep an eye on this process. With regards to audit outcomes, the OCJ's improved outcomes audit is welcomed, in which it satisfactorily addressed the challenges of the previous financial year. This is largely due to the improvement of the quality review processes that it has implemented and maintained. Vacancies continue to be a problem, particularly in senior management, which remain higher than the norm at 12.8%. With regards to court modernisation, the rollout of the court's online project to further superior courts has again been delayed, partially because of the Constitutional Court and Supreme Court of Appeal will now receive that rollout. The OCJ reports that depending on ICT infrastructure, readiness and the system stabilisation, it will prioritise further rollout to other courts in 2023-2024. This lack of progress to date remains disappointing. The project is vitally important to efforts to make our courts more efficient, and therefore recommended that the incoming committee include the rollout as a priority focus area. Storage of court records and digitisation project remains an issue. A lack of space makes storing court files challenging. The implementation of the court online solution should assist going forward, but does not address the challenge of storing older records. The OCJ has made a submission to the IJS for funding to assist with the digitisation of old court records, and this is another area that should enjoy the focus of the Minister. With regard to court infrastructure and other arrangements, during the committee's oversight visits, it noted various challenges relating to the infrastructure and more generally relating to the accommodation arrangements of the superior courts visited. Some of the newer courts that have just been built are falling down around the heads of the personnel there. There are courts around the country that are in a state of serious disrepair, and I know that the Deputy Minister today conducted unannounced oversight visits, and I'm sure that he himself noted some of the problems that they're forced to contend with. A follow-up meeting in this regard should be prioritised by the committee. The annual budget for the OCJ is 2.4 billion for 24-25, compared with the 2.3 billion during the previous financial year. It's broken down as follows. 1.2 billion was allocated to the OCJ's 3 programs of administration, superior court services, and judicial education and support. 1.17 billion is the direct charge from the National Revenue Fund for the judges' salaries. The planned expenditure over the MTF period, the OCJ aims to strengthen access to justice by ensuring effective administration through the modernisation processes and infrastructure in the superior courts in an effort to optimise court proceedings over the next few years. A cloud-based digital platform will be implemented that is aimed at providing online case initiation, case management and evidence presentation. This is expected to result in an increase in the finalisation of default judgments from 76% in 2023-2024 to 93% in 2026-2027, and of costs from 85% to 99%. This forms part of the broader integrated criminal justice strategy led by the Department of Justice and Constitutional Development, which aims to increase the efficiency of the entire criminal justice system. To enhance the turnaround time in dealing with cases, the court online system is expected to be rolled out in 2024-2025 to the Labour Court, the Labour Appeal Court and the Land Claims Court in Gauteng. The system is intended to be implemented in all courts as determined by the judiciary. For this, 538.6 million is allocated over the next 3 years. The budget will implement cost containment measures. Ability to discharge its mandate. The strategic direction and contribution to the National Development Plan. In implementing its mandate, the OCJ provides support to the judiciary in contributing to Chapter 14 of the NDP. The contribution to this NDP priority is done through strengthening judicial governance and the rule of law as follows: accelerating reforms to implement a judiciary-led court administration, ensuring an efficient court system, reducing court administration and inefficiencies, and ensuring access to justice. The contribution to the medium-term strategic framework In its endeavour to realise the 2030 vision, government has realigned its strategic intent and taken an approach of a targeted set of focused priorities for the 2019 to 2024 planning period. The OCJ has a national priorities during the medium term. The OCJ will demonstrate how it will contribute to the MTSF by following the following priority areas. Addressing fraud and corruption, promoting an ethical culture, integrating Bottapele principles, adherence to corporate governance principles, improved court operation systems and modernization of the court processes and systems. Key issues for consideration by this 7th Parliament should quite possibly be the incoming committee may consider tracking finalisation of the court administration model. Delays in the court modernisation and digital transformation project is an area for oversight by the committee. A fully functional and modernised integrated justice system, collapsing court infrastructure and security concerns, and operational weaknesses in the electoral court. Those being the most pertinent issues, I thank you.
Thank you very much, Honourable Member. MK, Honourable Dr. Hlophe.
Thank you very much, Chairperson, Honourable Minister, Deputy Minister, Honourable colleagues, ladies and gentlemen. I stand here representing the MK party. I just want to say before I make my input, which will be extempore, we did not get the relevant documentation timeously, and that has put me in a tremendous disadvantage. But I will make my input extempore nevertheless. The first input from the MK is this. We note that the budget has been decreased by 13%. In real terms, this means the courts have to do more and more with less and less. More and more work must be done, but with less and less resources. That's what it means in real terms. The problem with that is the following. In the case of the higher courts, for example, we all know there is a huge backlog. I'm not aware of a single court, high court in this country, which does not have a backlog, particularly cases. This is as a result of a wide range of factors in criminal cases, ranging from load shedding. The other one has to do with the fact that it is often difficult to get prisoners who are appearing in the courts for trial timeously. These are all factors that impact on the finalization of cases timeously, and this causes a huge backlog. Inevitably, the heads of courts have to find a solution. They often resort to the professions and call for attorneys and advocates to come and act on a pro bono basis. They would volunteer their services, they don't get paid. The problem of the head of court is put at a tremendous disadvantage. In some courts, you would have 20 or 30 pro bono advocates or pro bono appointments. I don't know how they manage that. It's a nightmare. Now, correspondingly, administrative staff have not been increased. There are many vacancies throughout the courts in this country which have not been filled. So that impacts on the quality of the work that must be done at the end of the day. Some of these pro bono counsel, once they are done with their work, they go back to the bar, they go back to the attorney's profession. And I've been told in some divisions, they are appointed as pro bono advocates, so as pro bono judges, but they are allocated other work in the normal role, which is wrong, because they are not appointed as judges. They are appointed pro bono. The other problem with the courts being short-staffed is that there are accused who are languishing in jail. In the case of a trial, where the accused person, after the trial, where an accused person has been waiting in prison for years and comes up for trial, and eventually he or she is acquitted. This has serious consequences, right? And the budget, I don't see how that has been factored in the budget to ensure that that doesn't happen. The budget, in my view, in our view, considered view as MK, fails also to ensure that during this 7th Parliament, we ensure that the access to justice is improved, particularly by those South Africans who live in rural areas. We all know that South Africans who live in rural areas and who are obviously vulnerable and poor, and if one were to use color, they are by and large black people who live in those areas. Those areas are not developed. Sometimes those areas don't even have bridges. It has been raining. They will not gain access to the courts because of lack of infrastructure in those areas. Maybe the department wants to consider other options that may be available. For example, having more and more circuit courts in those areas. Access to justice, particularly in remote areas, is still a huge challenge for us. The other problem about online services, it's an ideal situation to have a paperless court. The problem is this: you cannot have a paperless court as long as you have load shedding. In order for us to have a paperless court, there must be no load shedding, so that there is access to electricity for 24 hours. This is why the online project we started many years ago will never be finalized in the foreseeable future, as long as we have load shedding. And load shedding does not appear to be going away in this country anytime soon. So as long as we have load shedding, the whole idea about online or e-filing is a dream that we will never be able to realize. The budget also, in our view as the MK party, doesn't take account of some of the realities which give rise to this caseload. For example, if one does research, cases of malicious prosecution are on the rise. I'm not talking about wrongful arrest. I'm talking about malicious prosecution. Those cases are on the rise and they impact on the budget of this department. Now, what is the solution? The solution lies maybe in part in training our prosecutors, right? Because they often arise in the context of criminal prosecutions. In the good old days, especially when it came to serious cases like murder, rape, you would find a senior prosecutor being allocated to the case much earlier so that he or she controls the investigation. I know for a fact, I sat in the Marike de Klerk trial where she was murdered, our first lady. The policeman was involved there. It was Captain Barkhazen. He was involved right from the beginning, and he worked very closely with the prosecutors. The result was a successful prosecution. So I would really urge you that you ensure that the budget takes account of that reality. I realize that I'm running out of time.
You still have 21 seconds.
21 seconds? Well, I want to stick to my time. Improved access, Melissa. Finally, we need, this is from the MK's point, to ensure that there is optimal use of court hours. I know that that is a very old story. It is as old as mankind. It's all very well to say, let's work with a limited budget, but we must make sure that there is optimal use of court hours. This.
Your time has run out.
No, that's fine.
Thank you.
Thank you so much.
I will call on the EFF, Honorable Advocate Kweban.
Thank you, Chairperson, honorable members, Minister, Deputy Minister, staff from the OCJ. Thank you for honoring me with this opportunity, the EFF. Chairperson, I will start by saying that the Constitutional Court we normally say in the Nkandla matter, was very clear that unfortunately litigation often is for the wealthy, and you'd find that the poor are not recognized. The poor do not have access to the law. And the challenge here is that we have the Office of the Chief Justice, which was established in 2010. And after establishing this office, it was to make sure that there's independence of the judiciary, and the judiciary should be helpful to the poor and the marginalized. But what is currently happening is that since then, the lower courts have not been included. There's the lower courts bill, which is supposed to be making sure that all courts are dealt with and are covered by the Office of the Chief Justice. So the office would have made sure that there is also independence. There won't be unlawful or unnecessary interference with the judiciary. The Office of the Chief Justice, in fact, was then had its mission to make sure that there's transformation, there is independence of the judiciary. But progress in establishing these courts has not been seen up to so far, because that lower courts bill is very critical. Actually, it's the starting point, because how many years now we're still waiting for that. Coming to then the role of the Chief Justice in ensuring access to justice, we are dismally failing as far as that matter is concerned, because the poor cannot minister, and honorable members and members of the public abakwazi ukuthi ba exercise and ba access justice. Si fanele si check ukuthi umuntu ose kuma rural areas uyai experience that particular process. So unfortunately, the current Chief Justice, the appointment yakhe was viewed as a and leadership yakhe is very much questionable. I mean, currently, Sine Land Claims Court, where there's a lot of incompetence and favoritism in leaving the lane claimants very much vulnerable. They only concentrate on evictions, but then they don't focus on the issue of land claims. Now, the Chief Justice will be issuing, apparently, the annual report for the performance of the judiciary. A question, Lapo, as members of the committee which have asked, Uguti, why do we only deal with the Office of the Chief Justice and forget about the performance as well of the lower courts, the functional performance? Because that's where we need to change. Uguti, people, are they really exercising to justice? Because we are now focusing on issues of the payments, issues as in an impact with the poor and the marginalized. So the neglect of the Land Claims Court is questionable. Another critical issue is nayo uguti the various courts, the conditions are deplorable, because if besinoguti ama courts, lower courts are under the Office of the Chief Justice and they are looked up to dilapidated courts. I mean, there are a number of courts which are dilapidated, and those courts as when you go there, you don't feel good you can access justice. The courts which I would mention, courts Mzumbe, Abo Mzumbe, Endwendwe, Emamilodi, where the courts do not have fully functional system. There are poor maintenance of the existing courts, kunama cracks, the buildings are not working, smelly. Those are the things people are experiencing on the ground. And the Office of the Chief Justice should be helping to handle those kind of things. We have situations, members of the public, where gender-based violence, rape victims, they are just left to be handled anyhow. There's no privacy in a number of courts where they are exposed to secondary abuse, because then you are raped, your court must be heard, you are subjected. Like there's one case in Bloemfontein where the family sat for 4 hours, and when they were called, the case was postponed. There's a lot of postponements. But then coming back to the judiciary and the office of the Chief Justice, what we are saying as EFF, we are saying the best way to handle a lot of backlogs, because there are a number of backlogs, it's also to change and have alternative dispute resolution mechanisms, have special courts, but also we need the judiciary to be techno-savvy. We cannot have a situation where Judge Tefu is issuing a judgment with notes, but we need a situation where they will have typed their judgments, they are trained on artificial intelligence, they can make sure that they do their work properly. Unfortunately, Chairperson, as EFF, we don't support this budget vote. We are saying more can be done to change and have an independent judiciary. Thank you.
Thank you, Honorable Member. IFP, Honorable Hadebe.
Thank you, House Chairperson, the Honorable Minister, the Deputy Minister, Honorable Members. At the outset, and on behalf of Inkatha Freedom Party, allow me to congratulate and thank Justice Zondo for the invaluable work he did as head of the Judiciary and the Constitutional Court during his term. Throughout the years, our country's judiciary has faced its fair share of public scrutiny and low levels of public trust. But public servants like Justice Zondo have worked tirelessly to address and restore public trust in our judicial system and courts. May this new government and the next coming Chief Justice draw on the lessons emanating from your work into a dispensation. According to Afrobarometer, only 43% of Africans say that they have faith and trust in our courts, compared to the 53% of South Africans who state that they have little to no trust in our courts. To put this into perspective, the report states that trust in courts is lower than in media broadcasters and the health ministry and the army. We are on the very edge of the precipice, Honorable House Chairperson, and we need a continued concerted effort from the Office of the Chief Justice to restore public faith in our courts and make constitutionalism and democracy in our republic and unsullied vestige and sanctuary for both present and future South Africans. Therefore, the IFP welcomes the programs such as Program 3 of this office's budget, the Judicial Education Support Program, aimed to provide education program to judicial officers, support services to the Judicial Service Commission, and the policy development and research services to the Department and the Judiciary Administration of Justice. The first step in improving public trust in our courts is to ensure that competent judicial officers and support staff are occupying the roles. Under the previous administration, we raised concerns about the fact that in 2022-2023, the number of personnel decreased. We stand by this concern, as we cannot have the number of personnel in the Office of the Chief Justice decreasing yearly. The Office of the Chief Justice is at the coalface when it comes to combating and meting out punishment in those who have committed crimes. Therefore, this office cannot afford to be understaffed. We appeal to the new government to ensure that the budget prioritizes keeping the Office of the Chief Justice fully staffed. The IFP therefore supports the budget. I thank you.
Thank you, Honorable Member. I will now call on the PA, but there is no name that was given of an Honorable Member that will speak. If there's any that is available from the Patriotic Alliance,
The GNU has spoken for them, Chair.
no order. Okay, we are passing. Action SA, there's no member as well that is stipulated there. Is there anyone? No one. The Honorable, the Deputy Minister.
Honourable, I hope that the members who aren't present's time comes to me. Honourable Chairperson, Honourable Minister, Ministers and Deputy Ministers, Honourable Members, members of the Judiciary, the Secretary General and officials from the Office of the Chief Justice, distinguished guests. As we meet here today, our thoughts are with those whose lives have been disrupted by the extreme weather conditions affecting various parts of our country, especially the Western Cape. We must mitigate the impact of these developments on the functioning of our justice system, including our courts. We also want to take this opportunity to convey our condolences to the families and loved ones, firstly of Professor Zonke Majodina, who passed away sadly last night, who was a member of both the South African Human Rights Commission as well as the UN Human Rights Commission, and also Frank van der Horst, the former late president of SACOS, who never tired of reminding us that there can be no normal sport in an abnormal society. When the drafters of the Freedom Charter meticulously crafted the historic document in 1955, they highlighted as one of the pillars that all shall be equal before the law. They also proclaimed that the courts shall be representative of all our people. These principles are mirrored in our Constitution. Both the Freedom Charter and the Constitution place people at the center of the justice system, at the center of the rule of law, and at the center of our courts. Whilst one can spend a lot of time discussing the nuts and bolts around expenditure trends or facilities or infrastructure, let us always be mindful that these things are there to serve the people, not as ends in themselves. Whether it's a person who approaches a court because they have nowhere else to go to have their matter heard, or whether it's a person whose rights have been infringed or a victim of crime who looks to the courts to ensure that justice is done, we need to keep people at the center of everything we do. At the same time, we need to see our courts and our justice system within a bigger picture. We've set many goals for our country, whether it's eliminating poverty and reducing inequality, or growing the economy, or creating a better Africa and a better world. Our courts and our justice system play a fundamental role in each and every goal that we've set for ourselves as a nation. A country with an efficient and effective justice system is much more likely to attract foreign and domestic investment, grow the economy, and create jobs. A country which adheres to the rule of law will be able to successfully build safer communities, build a capable and developmental state, and contribute to a safer region, a better Africa, and a better world. A country with an accessible justice system and strong and respected institutions will ensure the protection and promotion of people's human rights and thus be able to free the potential of each person. Indeed, our courts and our justice system are vital to every aspect of our country's success. The Constitution compels us to assist and to protect our courts, to ensure their independence, impartiality, dignity, accessibility, and effectiveness. For this reason, the Office of the Chief Justice was established in 2010 to support the Chief Justice in the execution of their administrative and judicial powers and duties as head of the judiciary. The transfer of the administrative functions and staff attached to the superior courts from the Department of Justice to the OCJ commenced in October of 2014. In April 2015, the OCJ became a fully fledged department with its own budget vote. The administration for the superior courts, the Judicial Services Commission, and the South African Judicial Education Institute were transferred to the OCJ together with the budget and the personnel from the department. When the OCJ was established as a national department within the public service, the intention was that this would be the first phase towards an independent, judiciary-led court administration system to fully realize the judiciary's institutional independence in line with the Constitution. The OCJ contributes to the National Development Plan's calls for strengthened judicial governance and the rule of law and ensuring an effective and efficient criminal justice system. The modernization and digitization of court systems remain key priorities for the OCJ. The use of technology in court proceedings is an invaluable tool for ensuring seamless access to justice, and therefore the rollout of the court online system remains key to improving court operations and enhanced service delivery. Also, the role of the South African Judicial Education Institute remains absolutely crucial. Honourable members, it's clear that our Constitution envisages a single judiciary. Section 166 of the Constitution makes it clear that our courts encompass both the superior courts as well as the magistrates' courts. Constitution 17th Amendment and the Superior Courts Act were all inspired by the ultimate goal of achieving a single judiciary. The Chief Justice has responsibility to coordinate the judicial functions of all magistrates' courts within the jurisdiction of that division of the High Court. This responsibility is being carried out by judges president of the various divisions. The department continues to support the administration of the magistrates' courts, and we're pleased to announce that 227 permanent district magistrates have recently been appointed with effect from the 1st of August 2024 to further capacitate the magistrates. With regard to the legislative framework, the Lower Courts Bill and the Magistrates Bill have both been published for public comment, and we're awaiting inputs and comments. My colleague, comrade and friend, the previous Deputy Minister John Jeffrey, met with representatives of the Magistrates Commission, the Regional Court Presidents Forum, Chief Magistrates Forum, and with stakeholder bodies such as ARAMSA and JOASA, and indicated that more in-depth discussions would follow on these two bills. The Chief Justice as head of the judiciary will also provide comments, and we're looking forward to receiving, studying, and engaging on them. It is at the same time important that in developing the two bills, we're also guided by the judicial governance and court administration model based on the criteria of institutionally independent judiciary. We also need to finalize the rationalization of courts. The Constitution envisaged in item 16.6a of Schedule 6 that the structure, composition, functioning, and jurisdiction of all courts would be rationalized with a view to establishing a judicial system suited to the requirements of the Constitution. The work being undertaken by two committees tasked with the rationalization of courts is at an advanced stage. Honourable Chairperson, indeed, we have much to do. I want to conclude with a few lines from a poem called Justice by Robert Longley, and I quote, "There can be no justice if we sit idly by. There can be no hope of change if people do not try. This is not a task for one group. It affects both black and white. It is the same is true in policy on the left and on the right. We must grow beyond labels. We must all stand as one. This is a time of challenge and much work must be done. I know we can be better. We all must rise above if we are to find true justice. First, we must find love. We stand here today at the start of this new term, the 7th administration of a democratic South Africa, and we carry on our shoulders an enormous responsibility. Our country, like other countries around the world, faces many challenges. In order to overcome these challenges, our justice system must work. Let us do the very best we can to support and strengthen our courts today and every day over these next 5 years, for the love of our Constitution
Honourable Deputy Minister,
and the well-being of our people,
unfortunately, you have exhausted your time.
and for the love of our country. I thank you.
Thank you. ACDP, Honourable Swart.
Thank you, Chairperson. May we, on behalf of the ACDP, firstly congratulate you, Honourable Minister and Deputy Minister, on your appointment, and we look forward to working with you to improve the state of justice in our nation. Now, we know that the OCJ was envisaged way back in 2010 as the first phase towards an independent judiciary-led court administration system to fully realize the independence of the judiciary. We also know the OCJ's core function is to render support to the Chief Justice in executing administrative and judicial powers and duties. But it is a state department which accounts directly to Parliament as they are doing today. Now, we as the ACDP remain concerned about the ongoing delays in the policy on judicial governance and court administration. We fully appreciate the judiciary's frustration with the lack of finality in this regard, given that the reports from the judiciary were tabled way back in 2013. Once more, Honourable Minister, we urge the finalisation of this policy and the legislation as a priority. Not only is it for the establishment of a single judiciary a constitutional imperative, but also the lack of the appropriate policy and legislative framework contributes to the many inefficiencies and other challenges that the judicial system experiences, as indicated by various other speakers. Chairperson, the OCJ continues to be affected by budget cuts, as highlighted in the presentation which the committee received and the committee report. These budget cuts have necessitated reprioritization of resources to support priorities, including court modernization, digitization to improve access to justice and the services of the superior courts. But it's not enough. It's not enough. And ongoing budget cuts are drastically the efficiency of the courts. Not to say the maintenance and those magistrates' courts that we in the last minister, serious infrastructure, maintenance, the lapid court challenges. The judiciary indicated to us in the previous parliament that they are frustrated at drawn and attending to their core function, largely because of challenges of communication between the Justice Department. These infrastructure problems highlighted by all of us are undermining the delivery of justice to our people and cannot be allowed to continue. Chairperson, we need to have more surprise visits, Chairperson. We need to, not the staged visits when we arrive, like we went to Kimberley last time and they said, well, first time the Kimberley court has been cleaned, the grass has been cut. We need surprise visits. Lastly, Chairperson, the ACDP would like to express its appreciation to the judiciary and to the OCJ for the support it provides for bringing justice to our people under very difficult budgetary and other conditions. I thank you.
Much, Honourable Member. I will now call ANC, Honourable Klego. Members, Honourable Ngola saved a minute. Order, please. Honorable Ngola saved a minute from his 8 minutes.
Yes, Chair, I'm
We
donating
have
it
then
to Mr.
allocated
Matafa.
that.
I'm donating it to Mr. Matafa.
Oh, okay.
Yes.
All right, then I will donating it to you because
According
I
to the
stick
rule
to
of
5
minutes.
minutes.
Yes, Chairperson, this donation of time is according to which rule?
Honorable House Chair, the Minister, Deputy Minister, the Judiciary, the SG, and the staff in the office of the OCJ, members of Parliament, our chairperson in the Portfolio Committee, members of Parliament, my colleagues, our guests, South Africans, I greet you this afternoon. Chairperson, let me start by thanking South Africans for ensuring fair elections on the 29th of May 2024. In the same vein, thank the voters of the African National Congress, my organization, for voting the African National Congress. That, Chairperson, resulted in a successful transition from the 6th administration to this 7th administration. Let me not really forget that this year marks the 30 years of democracy, and our democracy is relatively young compared to the democracies of the world. South Africa and freedom for all. We now have the 7th administration, which is a product of that democracy. A democracy that also enforces transformation in the judiciary, ensuring that previously disadvantaged individuals, including women, are taking up space and occupying critical positions in the justice system. We all have access to justice. We are all equal in the eyes of the law, which proves the independence of the judiciary. As a country, we need to defend the gains of democracy. As a committee, entertain APP and the budget of this office, which has a history of commendable performance and acceptable, which are as a result of their performance and our robust oversight as the Portfolio Committee. We will continue with our oversight responsibility over this entity as required by the law. Our oversight function will include, amongst others, ensure performance, including vouching for fewer budget cuts, so that the office remains independent. This budget vote contributes to the effective administrative and technical support to the Office of the Chief Justice. Chairperson, as South Africa, we come from a shameful history of racial and gender discrimination against women. Before 1994, there were no blacks on the bench of judges. Legal means were used to advance. It was during this democratic dispensation that saw the likes of some judges ascending to the benches of this constitutional court. Today, the bench is more representative than it was before 1994. Credit goes to our constitutional democracy and the ANC's transformational agenda. And other organs of state must continue with their transformational agenda. The judiciary is the guardian of the Constitution, which defends and upholds people's rights. In advancing this obligation, the ANC welcomes and supports the budget allocated to this office as tabled by the minister in the House, hoping that the budget will address any shortcomings, amongst others, filling of critical vacant positions. I appeal to all South Africans to join hands in defending the gains of our democracy.
Unfortunately, your time is...
The ANC supports this budget. Thank you.
I will now call upon NCC. If there is a member, there's no one that is allocated here. NCC. Okay. ANC. Honorable Matafa.
Let me start by congratulating you in your election as the chair. Members of the executive, members of parliament, members of the office of the Chief Justice, South Africans. Let me also join in wishing the Chief Justice Zondo well for the future and commend him and the team for continuing with the agenda of transforming and modernizing the judiciary. The African Board's Vote 27, Office of the Chief Justice. The importance of the judiciary and the purpose of this budget vote has been emphasized by speakers before me. In terms of Section 165, Sub 4 of the Constitution, it is incumbent on organs of state to assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. A vote in support of this budget is critical for the effective and efficient functioning. Affirms our support as the ANC for the rule of law and the independence of the judiciary. Chairperson, 30 years ago, we achieved our hard-won freedom. We adopted the final constitution in 1996. Over the years, the judiciary has shown profound understanding of the constitutional imperatives as set out to defend the basic law of the land. Our courts, particularly the Constitutional Court, have developed rich and transformative jurisprudence, which has and continues to benefit the masses of South Africans. It is important in a democracy that individual judges and the judiciary as a whole are impartial, independent of all external pressures and of each other, so that those appear before them and the wider public can have confidence that their cases will be decided fairly and in accordance with the law. When carrying out their judicial function, they must be free of any improper influence. Honorable members, the committee knows that the OCJ obtained a clean audit outcome, an improvement from the previous financial year. In the previous financial year, the OCJ received an unqualified audit opinion with findings on compliance with legislation. There had been a regression as the OCJ had achieved clean audit opinion since 2017-2018. Therefore, this improvement must be commended. This demonstrates the commitment to financial prudence and accountability. Notwithstanding this, the OCJ is seized with a number of challenges, some of which have been highlighted by the Minister and the Chairperson, the obvious one being the issue of budget cuts, which are projected to hamper efficiency and effectiveness in delivering service. This is a concern for the ANC, and we implore the National Treasury to look at this area with keen interest. Chairperson, since the dawn of democracy, the country has seen a rollout of courts throughout the country. To date, all 9 provinces have at least one high court, confirming that serious efforts are afoot to improve access to justice. Undoubtedly, we are living in a digital age with the 4th industrial revolution upon us. The use of technology is ever increasing, and the COVID pandemic accelerated the importance of embracing technology and adapting. We are in a position where we are reimagine a judiciary of the future, ensuring access to justice by all in a rapidly changing world. The judiciary, supported by the OCJ, continues to prioritize information and communication technology as a strategic enabler. Technology plays an important role in ensuring an efficient court system. It has developed initiatives, online system, which aims to provide a platform for filing documents to the courts electronically, the physical movement of people and paper-based court in regards to litigation. The court consists of two separate components: a case management solution, which is mainly a customer and evidence management solution, which deals with case lines. This is beneficial for storage, retrieval, and management of electronic documents on the filing system. Modernization of the courts and digital transformation initiative remain a crucial role for improving service delivery. Research shows that case lines have been effectively incorporated in the various global jurisdictions, including the United Kingdom and the United Arab Emirates. And while encouraging some initial hurdles, while encountering some initial hurdles inherent to a new system, case lines offers numerous remedies to the issues typically encountered in traditional systems. Judges benefit from convenient access to comprehensive electronic court files before hearings, and the system enables the establishment of virtual hearings, even in challenging circumstances such as pandemic with its accompanying limitations. The Office of the Chief Justice has outlined some of its ICT challenges. We encourage it to attend to them to ensure that the justice is done in a speedy and efficient manner. Madam Chair, the ANC once again supports the budget vote 27 OCJ. Thank you very much.
Thank you very much, Honourable Member. I will now call upon the Honourable the Minister.
Thank you very much for the opportunity once more, House Chair. Colleagues, let me start by appreciating all the inputs that have been made by various political parties that were able to make an input. Honourable members, quite a lot of what was raised here, yes, it is true. Yes, it is challenges that we are facing. But I think we need to start from a point that in the allocation of funds and resources from the fiscal, it is never possible for the fiscals to cover each and everything that is a desire of any other department. In our endeavor with the Deputy Minister to try and reach out to the challenges that will be emanating from the budget cuts, there's quite a number of initiatives which we have begun to discuss, which addresses some of the issues which have been raised here and some that might have not been raised. For example, our filing system in our court systems might have not been raised, but is part globally of what the digitization strategy of the department is about. So the budget cuts, yes, are a challenge, but there are creative ways in which we could be able to resolve issues. For example, we are a custodian of the CARA fund, and our request to National Treasury will be for us as a department to collect more on behalf of the work that we are doing. A threshold needs to be cut to keep the services or the funds so that we are able to reach out. And something new in government, if you look into the funding strategy and that is received, you collect, you get a portion of what you have collected for you to be able to re-enhance the work that you are doing. And that's the strategy. And the department has done well. The fiscus is seeing benefits of the fund, but we actually need also allocation from the fund to be able to assist us. We are in line to meet with the Department of Public Works, want to increase the threshold for maintenance for manual work. That could be done by the department from the million that it is at. I took on the report, look at and suggest is that Africans find the mandate of the department not supposed to be a turnaround to access more delays, ensuring that access to justice does happen from the 43 versus the 57% that is currently happening. So if you are able to enhance that work, this morning took a surprise visit to Kaelicha in our court, just to make sure that we don't live by the grass that is cut because the minister is coming today or tomorrow. So where we are and we are doing our work, we'll deliver. And there's quite a bit of findings. There's already drafted a report on what needs to be done and how to assist. So we're hands-on on the job to ensure that we bring the alternative dispute that Honorable Sisbusi spoke about. Traditional court have also been enacted. That will also be assisting in one way in dealing with the backlogs that our court. We are working closely with the department to ensure that the delineation and the framework on the handover and the to be able to start with the work and the dispute mechanism will also be another way of how we assist the role. The importance and the focus of some of the issues that the department and the Office of the Chief Justice will be dealing with involves the infrastructure in rural areas as well, which Honorable ensure that we the services either online or physical, allowing the conditions. For example, we are budgeting for backup generators. In some instances, access to boreholes, to ensure that the small and rural courts can still be able to afford the service of access to justice to our members. It may not be all of them in one financial year, but surely we are on course in ensuring that our partnership and our activities with the entire cluster of crime prevention realize its mandate. Thank you very much.
Thank you very much, the Honorable the Minister. We have come to the end of the speakers list. And when we started, I had reminded members that there are two debates that are scheduled simultaneously for 16:30. The International Relations and Cooperation Budget Vote debate, which will be held in the Good Hope Chamber, while the Mineral Resource and Energy Budget Vote debate, which will take place in Committee Room M46. That concludes the debate and the business of this mini plenary session. The mini plenary will now rise.